Hello students, welcome to my channel. Today we are going to see the Clat PG paper. So Clat 2022 PG paper is being analyzed here, and in this section we will analyze the constitutional law section of the Clat PG. So before I start analyzing, please consider subscribing to my channel. So the Clat PG paper was totally different from the previous years. This year the passages were lengthy, the questions were little different. Usually when they ask such passage questions, usually they don't ask questions directly from passages, but of the 10 questions, some of the questions can be answered just by reading the passages. And moreover, I can feel that there was emphasis on there was an emphasis on application of mind in this paper, that the examiner wanted the students to apply the mind rather than remember the factual concepts. So today we are going to see about constitutional law. So in constitutional law, two passage questions were asked, and it is usually for 20 marks. So two passage questions were asked and for 20 marks. So the passages were, one is from the fundamental rights section, that is fundamental rights section that deals with right to religion. Of course, the famous Ayyappa temple issue was asked, and the other is from the state legislature, that is the ordinance making power of the governor. So without further ado, let's go straight to the question. So if you look at the question, I'm not going to read the entire paragraph, so which would save us time. So this paragraph, the first, this is the master question paper that has been uploaded in the Clat website. So in this master question, the first question is a paragraph that is taken from the Indian Analyis Association of the State of Kerala. So the Indian Analyis Association versus State of Kerala is the case in which the Supreme Court gave the famous Sabarimala judgment. So the first question is, in Indian Analyis Association versus the Supreme Court of Kerala, the Supreme Court held that the worships of Lord Ayyappa, the answer is, are not religious denomination because they do not have a distinct name, a common set of beliefs and a common organizational structures. So not only the judgment in the Ayyappa case, that not only the judgment was regarding the women's entry into the temple, the judgment also gave another controversial decision, saying that the devotees of Ayyappa are not an distinct or a religious denomination. They were just part of the Hindu belief system. If you look at the exact paragraph, this is the exact paragraph. I have the judgment here, and this is the exact paragraph where it was held, and this was in the Justice Nariman's judgment. So here he is clearly stating that in these circumstances, we are clearly of the view that there is no distinct name given to the worships of this particular temple. There is no common faith in the sense of a common belief to a particular religion or section thereof, or common organization of the worshippers of Sabarimala temple so as to constitute the said temple into a religious denomination. So clearly the answer for the first question is B, and let's move to the next question. So the Supreme Court determined whether religious practice falls within the Article 25 using, so this is a very straightforward question. So the answer is using the essential religious practice test. So this is the test that Supreme Court uses to identify whether a particular set of practices fall within the protection of Articles 25 and 26. So the answer for the second one is the essential religious practice test, which was given in the case of the Tandava dance case. There was a Tandava dance case where whether the Tandava dance was held to be not an essential religious practice. So this again, the essential religious practice test was the test that Supreme Court uses. And again, if you go to the if if you go to the judgment, the essential religious practice was was something that keeps repeating as a theme in the judgment. The justices speak of this judgment. So here it is clearly that the essential religious practices was was discussed, and if you look at the judgment, you can see there are various cases. This Adi Saiva Sankaracharya Nala Sangam, this case was also something related to the essential religious practice test, and some of the other cases like I said, that the Tandava dance case and other cases. So next question, we'll move to the next question. So the next question is, the parliament gave effect to Article 17 by enacting. The answer is Protection of Civil Rights Act. This is the answer. So the Protection of Civil Rights Act 1955 is the answer. So this is a very tricky question, but if you know that the Protection of Civil Rights Act is something that abolished untouchability, it's an act that is made out of Article 17, then it would be easy. Otherwise, you can get confused between the Abolition of Untouchability Act and the Untouchability Offences Prohibition. Next, this is a question. This is where this year's paper was very unique, and it is unique in the sense that even though not separate questions were asked, but the examiner has asked a certain ancillary topics. Like if you say constitution, the interpretation of constitution is very important. So here, if you look at this question, this is straight out of an interpretation principles. So statutory interpretation. So here, Justice D.Y. Chandrachud's reliance on Constitutional Assembly defense to determine the scope of Article 17 is best explained by his method of constitutional interpretation. So here the answer is originalism. So this is again a question on interpretation, principles of interpretation, and if you look at textualism is something that's of literal interpretation. There are various principles of interpretation, like the literal rule, golden rule, originalism, etc. And there was a question on Justice D.Y. Chandrachud held that Article 17 has. So here, because Article 17 is something that has been exclusively for not exclusive, I should not use the word exclusive, that has been specifically made for the practice of untouchability, which is usually practiced against the scheduled caste community in India. Here Justice Chandrachud is invoking that Article 17 to a subsection within to a subsection or to a section of women. So here the answer would be the horizontal application. So here it is the horizontal applications. So now we all know that there is a review petition that has been filed against the judgment, and the Supreme Court has framed the following questions. So whether the scope of public order, morality and health in Article 25, what is the scope of public order, health and morality in Article 25? Again, we all know that the judgment in Sabarimala case is repeatedly talked about the principles of constitutional morality and what is in fact a constitutional morality. And again, the scope of expression of section of Hindus, again this is something that has come straight out of determining whether straight out of the judgment, which said that religious denomination, the Ayyappa devotees do not form a separate religious denomination. And next, the scope of judicial regulations to PILs filed by people not belonging to a religious denomination to contest religious practice, and this is something that was controversial during that period of time. Even many said that many women of Hindu fold said that we do not agree to the judgment of Supreme Court. They felt that this is something that is entering into the private religious sphere. In fact, some of them said that the petitioners to the case were not Hindus or they were atheists, etc., etc. So that might be the reason why the Supreme Court has framed these questions. So the answer for this question is D, all of the above. So all of the above is the answer for the question. Next, which judge on the bench in Indian Analyis Association case disagreed with Chandrachud on the application of Article 17? So we all know Justice Indu Malhotra, despite being a woman, was one who gave a dissenting judgment. So this is a very straightforward, easy answer. If you would have followed the judgment in close, you could have easily answered this question as well. In reaching his conclusion on the scope of Article 17, Justice D.Y. Chandrachud cited which of the following works of B.R. Ambedkar? So again, this is something of a factual question. So we all know annihilation of caste is a book written by Ambedkar. So if you would have known that this book was written by Ambedkar, you could answer this question. And coming out as Dalit, I don't think so. It's a book written by Ambedkar because Ambedkar was a Dalit and it was well known fact during his time. So it was another, you could have made some, if you would have known that it was annihilation of caste, then this is a straightforward answer. Again, in the passage above, what does the term non-derogable means? So non-derogable means it can any right that can be infringed under any circumstances. Again, if you read the non-derogable provisions, these are straight away coming from the human rights principles, because when you make certain human rights principles or certain human rights treaties, when the countries go and sign those treaties, there is this concept called reservations. There is this concept called reservations in international law. So what is reservation? Reservation particularly referred to is that reservation means when you sign treaty, there will be various sections or various provisions of treaty for a particular provision. For a particular provision, a country can modify the legal effect, modify or nullify the legal effect. But there are certain basic human rights principles which cannot be derogated, like the right to life or right against torture, genocide, etc. So it cannot be infringed under any circumstances. Usually the non-derogable principles are talked with regard to the emergency principles. So there are certain exceptions for emergencies, but when a right is called as non-derogable, it means even during the emergency situations, the state cannot do away with this right. Right to life under Article 21 is one such right which cannot be derogated under any circumstances. The petition filed by Indian Analyis Association in this case was, again, it's a public interest litigation. So the answer is B. So the answer is B. So it is a public interest litigations. The answer is B. So next question on constitutional law was from the state legislature aspect. So it is about the ordinance making power of the governor. I wanted to emphasize that a governor's power and governor's ordinance making power has always been tested by the Clat examiners. So again, there is a question on the ordinance making power of governor. So this is a very, very important topic if you are preparing for next year, or if you are preparing, do focus on the governor's ordinance making power. So it is about Article 213. So if you are thorough with Article 213, you could have easily answered this question. So the power to promulgate an ordinance is an instance of, again here, various judicial principles has been put. So you must be having a good idea of what is an executive power and what is a delegated power and what is a sovereign prerogative power of the governor. So once you have a good understanding of these principles, you could go ahead and answer these questions. So the question here is, the power to promulgate an ordinance is an instance of So whether it is an executive power, no, it is not an executive power. Of course, promulgation of ordinance or making of ordinance is a legislation. It's a legislation. So because ordinance has the same effect as the law, so it is not an executive power, and it is not a delegated power also. So the legislature is not delegating to the governor. So delegated power is something that is with regard to administrative law. So it is not a delegated power. And sovereign prerogative. So we know India is a parliamentary democracy, and the sovereign is the people, and the will of the people is what sovereign as per our constitution. So again, at all times it is the parliament that will be sovereign. So even that is not the answer. So the right answer would be D, none of the above. If there is an option which said that it was the legislative power of the governor, then you could choose that. You could have chosen that option. Next, the Constitution bench in DC Vadva was the state of Bihar. Again, a landmark judgment held that re-promulgation of ordinance was a fraud on the Constitution of India, because it again, see, this is where the principles of constitutional law principles, like you must know what is doctrine of colorable excise, you must know doctrine of eclipse, and all those things. So here, whether the answer is straightforward B, it is a colorable excess of power under Constitution of India. So simply put, you cannot re-promulgate ordinances because the ordinance making power is an exceptional power, and it must be practiced only when both the houses of the parliament is not in session. Sorry, or if it was the state legislature, when both the houses is not in session. So you cannot. There are set guidelines for ordinance that it must be laid before the legislature once it reassembles. So all these things has to be followed. So if we keep re-promulgating ordinance, then it will be considered as a fraud on the constitution. Let us analyze the other options, whether it is the legislative power vested in the legislation by the Constitution of India. Again, I said there is a specific power given to governor to make ordinance. So we cannot say it is a legislative power vested in the legislation of Constitution of India. And the role of the executive is to implement a law and not to make it. So here, although this might seem to be a general statement, but in India, the role of governor is a kind of mixture. So we have. It's not that he is an executive. He also has powers to make laws. So that is where another beauty of Indian Constitution, which has its own unique features. In states which are bicameral, the governor can promulgate ordinance only when the answer is straightforward A, both the houses are not in session. So one of the important requirement here is that in states which are bicameral, the governor can promulgate an ordinance only when both the houses are not in session. So bicameral means there are certain states which has two houses, the legislative assembly and the legislative council. So the answer is A. Next, under Article 213, an ordinance once promulgated by the governor shall be laid before the legislative assembly of the state or where it is bicameral before both the houses, keeping in mind the constitutional provisions. An ordinance promulgated by the governor can remain effective for a maximum period of. So again, an ordinance can be effective for a maximum period of 7.5 months. So here it is clearly given that once the house reassembles, so one of the conditions for making ordinance is that both the houses should not be in session. So this period would be 6 months. So 6 months is the maximum period from which both the houses should not be in session. So taking this 6 months, so once after 6 months a parliament or a legislature reconvenes, then there is a time of 6 weeks before which the ordinance has to be tabled before the house. So in total an ordinance can be in effect for 7.5 months. So the answer is C, 7.5 months. K.K. Singh overruled two 5-judge decisions of the Supreme Court to hold. So here it is an ordinance which is not laid before the legislature in the manner prescribed by Article 203 shall not have any legal effect and consequences. An ordinance which is not laid before the legislature in the manner prescribed by Article 2 shall be void from the date it should have obtained approval. So these two these two are similar. So the answer, the C is an ordinance which is not laid before the legislature in the manner prescribed by the Article 213 shall be void from the date the ordinance is replaced by a law made by legislature to replace the ordinance. So again, this is a very complicated thing. So this is not option. This option is definitely wrong. An ordinance which is not laid before the legislation in the manner prescribed by Article 213 shall be considered as a temporary statute, and again there is no such thing. So this is also wrong. So the answer must be from either of these two questions. So if you look at that, the answer would be A. An ordinance which is not laid before the legislation in the manner prescribed by article shall not have any legal effect and consequences. So this is a kind of a very complicated. The wording itself is very complicated. Shall be void from the date it should have obtained approval. So this is something is not the right answer. Next, 16. An ordinance promulgated by the governor shall be treated to be law for the purposes of Article 13 of the Constitution. This is absolutely right, because this is what is this is right. Shall in all cases require the prior approval of president. So this is wrong, and shall not be constrained by the subject matter requirements of Article 246 read with the 7th schedule of the Constitution of India. So again this is wrong. So the answer is A, 1 alone is correct. Next, Article 213 requires the governor Article 213 requires the governor to reserve an ordinance for the consideration of the president. So here again, so this is straightforward from Article 213. So the answer would be, in all cases when the state is placed under president rule, this is a very exhaustive kind of description. So there is no such thing that a governor has to place all the ordinance before president rule. So this is definitely wrong. Then when the ordinance pertains to the provision to the Article 304B and seeks to impose reasonable restrictions in public interest and the freedom of trade and commerce or intercourse within that state. So this is right. So this is given in Article 213. So again this is right. And when ordinance is on a matter enumerated in the concurrent list of the 7th schedule which is repugnant to a law made by parliament, and again this is also right. So the answer would be 2 and 3 are right. The power of the governor to promulgate ordinance is subject to governor being satisfied that circumstances exist which render it necessary for him to take immediate action. So this is again a tricky question. So here it's not subject to judicial review, so it is a political question. This is absolutely wrong. None of the above is also wrong. So the answer must be from these two options. is subject to judicial review with regard to relevancy of material, is subject to judicial with regard to adequacy of materials on which such satisfaction is based. So, the answer is with regard to relevancy of material. So, whether we have to identify whether the material on which the governor took decision was relevant. So, the answer is B. Section 6 of General Clauses Act 1897 protects rights, privileges and obligations and liabilities in cases of repeal of an enactment. The majority in KK Singh held that. So, here an ordinance that ceases to operate is distinct from law is void. An ordinance that ceases to operate is distinct from a temporary statute. An ordinance that ceases to operate is distinct from a repealed statute. An ordinance that ceases to operate is not saved in the absence of any saving clause in Article 213. So, here it is General Clauses Act. Again, I told this is something where the examiner has incorporated various ancillary subjects of Constitution. So, the answer to this question is D. All of the above are correct. Next, there is a legal principle question. A resolution by legislature disapproving an ordinance promulgated under Article 213 by governor is statutory nature and has a binding effect upon the government. A mere expression of the opinion of the House. Again, this is wrong. This is very vague description. And decision of the House relating to the control of the proceedings. Again, this is a very vague description. An exercise of delegated legislation. This is not a delegated legislation. So, the answer must be A. So, thank you. This is the end of the analysis of Clat LLM paper. So, we will see with the next topic or the next section in a different class. Thanks for joining. Do subscribe to my channel.